As has been the case this entire week, Room A is live streamed for the parties' record. So Mr. Nicholas was here on October 28th. On that date, the prosecutor's office requested a no bond hearing, which this court granted. We checked with all the witnesses who were present on that day, and everyone, including defense counsel, said they would make themselves available this morning for the no bond hearing. Today is the third day, and to my knowledge, defense has not executed a 5-day waiver. Is that correct?
Yes, Your Honor.
All right. So between Tuesday and today, this case was indicted. The indictment takes the case out of the jurisdiction of the municipal court. So now Hamilton County Common Pleas has the case. Based on our Tuesday conversations and knowing that all parties were going to be present today expecting a no bond hearing, this court contacted the court administrator for Common Pleas, Tom Baradon. Mr. Baradon apparently took it to the Common Pleas commissioner or assignment commissioner, had the case rolled. The case was rolled to Judge Jennifer Branch, who has agreed to come in at 9:30 this morning, and Judge Branch will hear the case at 9:30. Since everyone is here, it will still go forward. It will be in room 320 of the main courthouse, 1000 Main Street. Again, Judge Jennifer Branch will conduct the no bond hearing. So at this point, the felonious assault, the domestic violence was indicted with the felonious assault. So both cases will go to Judge Branch's room for a hearing in about half an hour. All right, does anyone else want to put anything on the record?
No, Your Honor. No, Your Honor. Thank you.
This protection order, I'm going to ask someone from the clerk's office because it was not executed. We were looking to do everything today, or it can go in the jacket, but I want everything that I have to go to Judge Branch because we're kind of scrambling.
Judge, I have the protection order here in the jacket, so I can give that to the clerk.
That's fine. I just want Judge Branch to have everything that I had today, so that you all don't have to continue this. All right, thank you.
All right. Thank you, Your Honor. Oh, no.
The court will be in recess until 9 a.m. when we do our regular docket. If you were here on Mr. Nicholas's case, you can go on over to the main courthouse, room 320.
Wait a minute. You guys up? Want to pick back up or not?
Yep.
Right.
Unless you all are ready, I'll stay out here.
Judge, give me just a couple of minutes.
That's fine. Just let me know when you're ready.
How many do you have? I'm on, it's just one guy that's causing.
All right, it's 9 o'clock. Let's get started.
Court's in session. Make sure your cell phones are turned on silent, please. Thank you.
Judge, first early call will be DeAndre Shannon.
All right.
Good morning, Your Honor. Dan Might, standing in for Courtney DiVincenzo. I submitted Ms. DiVincenzo's designation. Your Honor, this was an arrest on a warrant, so probable cause has been found.
All right.
As to,
to bond.
thank you, Your Honor. Your Honor, Mr. Shannon denies the allegations. He is alleged to have driven the shooter to a location, but he denies the allegations. He's not alleged to be the shooter. Mr. Shannon is 34 years old. He's a Cincinnati native. He attended Life Skills, ultimately got his GED. He has a stable address at
Hold on. Sorry. We turn the record off in the breaks between cases. So probable cause has been waived.
Yes, Judge.
That's the one. Thank you.
And, Your Honor, he has a stable address at 1997 Waycross Road, where he lives with his sister. He has worked, he's not working right now, so he can't afford a very high bond. He has worked in the past as a medical transporter. Judge, we'd ask the court to set a reasonable bond.
From the state.
Your Honor, the date of this offense was 9/29 of 2024. In the intervening year, officers have conducted an investigation and have identified Shannon as a suspect and as one of the perpetrators in the murder of Benny Bird. The part of that evidence is noted in the complaint and affidavit involving phone records and DNA evidence as well. So that would certainly explain for some of the delay. But the officers are requesting a high bond. In reviewing Mr. Shannon's history, it is apparent that he is a serious risk to public safety. The risk to public safety comes from, looks like he did federal time for conspiracy to possess heroin with intent to distribute, possession of firearms, and drug trafficking. It also appears that felony possession of a firearm, felony attempted possession of heroin, but most notably, it appears that he has a prior conspiracy to commit murder. He was released in 2023, which was the year before this. The facts and circumstances of that case are very similar to this case, where he would either set up or provide transportation for another person to actually commit a murder. So for that reason, we are going to be asking for $3 million secure, EMD, and no firearms. And I do not know if there may be older, but
There are 2 prior violent felonies, 7 felonies, 1 misdemeanor, 4 prior failures to appear. There is the prior conspiracy to commit murder, where Mr. Shannon was released in 2023. Is there a particular reason why the state is not requesting a no bond hearing when there is a prior murder? And He was charged with murder.
Judge,
I understand the officers asked for a high bond, but
understood. Just the evaluation of my discussions with the detectives.
did you have any?
Judge, I've got him on a misdemeanor, not guilty. If the court could just set a cash bond, so he's getting credit. Not clear if those are related at this point.
I don't believe it is.
These are not.
Sounds like they're not.
On the menacing, well, on the murder, probable cause is demonstrated, $3 million secured bond plus EMD. On the menacing by stalking, which is a misdemeanor of the first degree, 10,000 secured plus EMD plus juris. On the illegal use of a tracking device, which is also a misdemeanor of the first degree, 10,000 secured plus EMD plus juris.
Thank you, Judge.
Thank you.
Judge, grand jury for the murder case will be $11.10. Fent, Andrew Fent.
Good morning, Your Honor.
Morning,
Jack Croce.
Judge, there is a co-defendant on this. Looks like Daniel Mitchell is the co-defendant.
Are we doing these together or separate?
Separate, you can do separate, as far as I'm concerned.
That's fine.
Okay. Your Honor, we would waive probable cause in this case.
Ask to bond.
Yes, Your Honor, the charge here is felonious assault. The allegation is my client was in a restaurant, left, there was a confrontation with a group of people. The allegation is he struck one of them with his fist. He is 31 years of age. He has had no contact in the last 5 years, according to the bond sheet. He scores out at a total score of 1. More importantly, when he, after this event occurred, and he found out that he'd been charged with a criminal offense, he contacted counsel, retained me to represent him. Came here yesterday and surrendered himself on this charge. So he has every intention of pursuing a defense. He has no significant history. There's no indication that based on this allegation, he's a danger to anyone else. It was a conflict. In addition, as I've said, more importantly, he of his own volition came here and surrendered himself to face these charges. With that in mind, I would respectfully ask the court to consider, given his score here and lack of history and no bond in this case.
From the state,
Your Honor, in this particular instance, this occurred on the banks on Sunday at or around the Bengals game. It looks like outside the fishbowl, Mr. Fent and others engaged in a fight with the victim. The victim was struck in the head. He lost consciousness. A witness and an associate of the victim steps in to help protect the victim, and this is more where the co-defendant comes in. He is struck with some kind of glass bottle or item, and he was there to protect that victim who was on the ground unconscious. It looks as if, although there's very little record, this is still a violent felony, a felony of the second degree. We're requesting monetary bond, EMD, stay away, no contact.
how many people were involved in this brawl?
Judge, I know of at least 4.
On the other side, Your Honor. Okay, on the other side, not on our side. And And while the allegation is someone lost consciousness, if they lost consciousness, it was for a matter of seconds because they themselves got up and continued the debate. The realities are these. The realities are there was a conflict. The conflict was within a group of people. It was brought on in at least our position, initially brought on by the 4 people that are not involved with us. The fact that this is a unique situation, it's a one-time situation, does not in any way mitigate toward the fact that my client is a danger to anyone or that he will reoffend. He lives in Dayton. So, an electronic monitoring situation, at least in my mind, he doesn't know the purported victims here. He has no interest in being in Cincinnati other than to meet his court obligations. And again, I don't mean to lecture the court because the court's fully aware of it, but these are allegations. And frankly, the facts have been presented are pretty scant also. The allegation here is there's an argument. My client hit someone with his fist. He has no history. He came here. He surrendered himself to face charges and to aggressively defend them. Given the fact he didn't even live here, I don't think he's a danger to anyone. We would ask that he be given an OR bond and be permitted to pursue an appropriate defense.
And I know the state asked for monetary bond. Is it asking for a monetary bond, a high monetary bond similar to other fraud cases?
Judge, we would, understanding that this type of behavior is obviously detrimental to the community as well as the nature of the harm. The victim lost consciousness. In reviewing the additional materials I've been provided with, it looks like when officers arrived, multiple subjects standing around a victim with visible blood and lacerations on the face. It appears that after the borough, they may have left. It looks like.
How were they found? Is there a video? Or?
Judge, what appears is that CBS has cameras which were able to corroborate the incident, as well as the Fishbowl, which is the local establishment, utilizes an ID mechanism that captures the image of their BMV issued state driver's license. So I believe that's how they were able to finally get to the conclusion of who everybody was.
150,000 secured plus EMV plus jurors requested. Yeah, you had to put together.
Judge, grand jury will be 11:10.
Mitchell! Come on. Mitchell, come on.
Good morning, Judge.
Council waive probable cause.
We will, Judge.
Esteban.
Judge Esteban, maybe could I address the facts? Just, I want to embrace what Mr. Croswell just said. I think there's some dispute over the use of a bottle and or who had the bottle. I also want to say that there are apparently camera angles that will establish that this was a self-defense issue. It was not something that Dan started, and it was not something that Andrew Fant started. They were in a position down at the banks with their girlfriends where they had no choice but to defend themselves. I will tell you that Dan is 32 years old. He's got 2 daughters. I'm sorry, he's got a daughter who is 6, a son who is 8. He has joint custody of those children. He also has shared parenting of those children. He was born and raised in Dayton. He lives and now raises his children in Dayton. He owns his own home in Dayton, and he operates his small renovation business. It's called Dan's Renovations. He's been in the renovation business for about 10 years, 4 years. as an owner and operator. He's got 4 part-time employees.
Hold on. If you have a cell phone, turn it off unless you need to go out in the hallway.
And Judge, like Mr. Fant, his aura score is very, very low. It's a 1, which suggests to me that not only is he likely to return during every stage of these proceedings, but the community is not at risk should he be released. I can tell the court that Dan does not have $150,000 that he can post with a surety, with a family member. I can tell the court that the most he could possibly come up with would be about $50,000 or 10%. Again, he does not know these individuals. He does not live in the area. I assume that the state's witnesses live in the area. He lives in Dayton. We would be more than happy to execute a no contact order, but we would advise the court again that he just cannot post a bond at $150,000. So we'd ask the court to consider the $50,000 and 10%.
From the state.
Judge, we would make a similar request for bond with Mr. Mitchell. In this case, or in his part of the case, it looks like it's a different victim. This victim was the one who was standing over the unconscious individual. And I'm looking at, again, after that person was on the ground unconscious, it goes on to say that officers were also able to witness via video Mr. Fent, approaching Mr. Eads and striking him in the head with a bottle. Okay, I'm sorry. Mr. Mitchell struck Mr.
It
Eads.
says in the.
Yeah, Eads, and he was the individual, so.
Judge, I will submit that the facts are inaccurate. The bottle was not something that Dan used at all. And I think it's unfortunate that we're trying to hash out the facts before the court to get to an appropriate bond. I will tell you exactly what happened. There was a confrontation between this other group and Dan and his girlfriend. Dan was alone. He tried to shove his girlfriend away from the situation and had no choice but defend himself. The videos are going to show that these other individuals took a very defensive, very aggressive stance, and the fight started. Dan struck one with a fist, and before the other one could be struck, his friend came to his aid, and that's how the other person was hit. We would submit with a bottle. So again, I don't, this is not really the place to hash out the facts, but that's from our perspective, and we think that a much lower bond is justified, given the absence of any knowledge, they don't know each other, the absence of any history, and the fact that he lives in Dayton and they'll have no contact while these cases are pending.
Mr. Mitchell has no record, no failure to appear, as defense stated, which is different than the co-defendant had some minor record with the action or allegations, the action, someone was not unconscious. The bond is $100,000 secured plus EMD plus juris if requested.
11:10.
Did you just, if the juris, yeah. So, judge, she's. I have added that he can be on, if he makes the cash portion, that he can be on EMD in Dayton, just so that they can monitor the jurors if there's a request.
And Judge, it won't change anything, but I just want the court to note, he also surrendered after we talked yesterday. He voluntarily surrendered to District 1.
Thank you. All right, good morning.
Morning, Judge.
Good morning, counsel.
Please not guilty, Judge.
All right, that's Devon.
Mr. Garcia is 29 years old, native of Guatemala, is employed full-time as a construction worker, Your Honor. Supposed to be at work at 8 o'clock this morning. Agrees to stay away from Stacy Troft, who I believe is the prosecuting witness regarding the theft. I have only 4 failures to appear, Your Honor. Have good contacts information for him. I have a good telephone number and a good address. Mr. Garcia understands the nature of the allegations here. Is eager to defend himself. And Your Honor has ensured me that he is eager to return to court. We'll ask for an OR, SOR bond.
From the state.
Judge, it appearing that it looks like this is a theft of Craftsman electric drill. We would certainly ask that there be a stay away from that individual that's listed in the complaint.
Mr. Garcia has 1 violent felony, 1 violent misdemeanor, 9 misdemeanors, 5 prior failures to appear on the theft charge, 2,500 anyway. On the resisting,
I just point out to the court that it appears to me that complaints are just bald assertions. I don't see any allegations that he struck any officer or pulled away or anything like that. It's just based on what the state here is officer observation. So I would ask the court to consider that as well. On the, what I see on the
are there any other facts as to
Resisting.
the
It's
resisting?
just a bald assertion.
Judge, as to the resisting, officers responded, and the defendant was in the process of throwing objects in the rear of the store that apparently had just stolen, that being the electric drill. When they tried to place him in cuffs to take him into custody, he refused those orders, wouldn't turn around. Eventually, they tried tasing him. That was apparently ineffective, and he was taken to the ground and then placed into custody.
Is that in the 527?
That's in the 527, yes.
Is there an affidavit to accompany the complaint?
I do not see.
I don't see that.
So the charging document has, based on officer investigation and observation, the OR plus no alcohol plus a tag unit on the misdemeanors, or the other misdemeanors except for the theft.
Understood, Judge. I appreciate that.
And then I also have the case ending in 109.
That's gonna be OR plus tag. And part of Mr. Garcia's record has convictions for public intoxication, which is why I'm adding the tag unit and no alcohol.
Una unidad de monitoreo transdérmico para calcular si usted ha tomado o no ha tomado alcohol.
Over injury, if there's.
It's RAC.
No puede tomar nada porque va a tener algo en la piel que le va a indicar a la fuerza y con un cuidado borracho.
I have a return, just give me one moment.
Ramondo? Yeah, I'm getting Teresa Cabo Sanchez. Is Teresa Cabo Sanchez in court?
Está presente aquí en el tribunal Teresa Cabo Sánchez. Teresa Cabo Sánchez.
So it does include their child.
Do you have a reminder too? Is that-
No, I'm just.
Oh,
That's where he's.
You got a child on this too.
Yeah, she, holding their two.
It's a 2-month-old. Yeah, it's just holding 30. Okay.
I'm so sick. All the time. I'm so sick.
And Dave, there's a man with a bunch of traffic, so I'm going to work out. So I'm not very right now. That's okay.
Council.
Oh, so yeah, not the worst of that. I don't have those.
Really?
It's a 2-month-old child.
Okay.
Is that great?
The extra vulnerability.
The court is back in session.
I think it's Ramondo's and it's okay.
Okay.
Yeah, here it comes.
Judge, this is Mr. Matone Ramondo. We're going to execute the TPO.
Va a firmar ahorita la orden de alejamiento, pero no se puede hacer acercar para nada la orden.
Did we call for the prosecuting witness in this case?
I think we did.
Judge, we did, on the TPO. In English and in.
Judge, Mr. Ramondo has executed the TPO with way probable cause.
Esteban.
We'll wait on the interpreter. Ready on bond. Judge Esteban, Mr. Matone Ramondo is 25 years old. He has one child with a prosecuting witness. He's from Guatemala, but he's been here for 8 years. He's a roofer, that's roofing here. I show him to have no record here, so for 8 years the 8 years he's been here, he's no prior court history. He denies any allegations that he hurt his wife. Says this was an argument where she asked him to leave and he did not want to leave his home where his child was, that he didn't put his hands on her and didn't hurt her. I'm noticing that the police, the bond preference is no preference. He can't make any bond. He's been out of work temporarily here in the roofing business. He doesn't have any money for bond. Given the fact that he's been here 8 years with no record and there's no bond preference, and that he's executed the temporary protective order, I would ask the court for a supervised OR bond. He has another place to live. And I have good contact information in terms of a phone number. He understands that he would have to live in another place than where his
domestic partner and child with. So we'd ask for supervised OR bond.
From the state.
Your Honor, it appears that in this incident, he, in addition to strangling, he struck the victim in the face, neck, and also bit her on her right thigh while holding their 2-month-old baby. Respectfully request monetary bond, juris if requested.
I don't have a DV form in here. Do you have?
I did
one
not
on
receive one
RC's
on this either this morning. Or at least at the time that I came over, they had not been sent to me.
So we don't know if there's a request for juris. And the assault and domestic violence are charged in the alternative.
It appears so, Your Honor.
As it's been stated, there is no record, no failures to appear. On the strangulation, 5,000 anyway, plus juris if requested. Same on the assault and domestic violence, 5,000 anyway, plus juris if requested.
And Judge, it looks like our grand jury report date would be 11/10.
Is that on everything?
That is on everything. Jeffrey Smith. Target is the store.
Well, Your Honor, Chris Capson here, Mr. Smith, was plead not guilty. Ask to hear this for bond. He's just posted yesterday on another unrelated matter, so he was hoping that he could do like a supervised OR. He has a stable address in Deer Park with family. He was able to post yesterday, but I don't know if he can afford adding on another one. He's already on bond support.
Because I do see the posting of the bond, or the case came in yesterday for an arrest on the 29th. Looks like this may have been this occurred the day before on the 28th, and this may have been an in-population service.
Yes.
There are four violent felonies, 6 violent felonies, 2 violent misdemeanors, 5 misdemeanors, 3 prior failures to appear, 1 pending case. $1,000 anyway, plus EMD, because his employment is listed as construction with non-set hours. I will do open hours on the EMD.
Yeah. I'm sorry, Judge, what was the cash portion of that?
$1,000 anyway.
RAC.
Quarters and a short recess.
And then. I mean, I'm still working on this.
We're just back in session.
Did we call someone? Did we call someone? That's me.
Mr. Steinkamp?
Yeah.
And I represented Mr. Steinkamp on Tuesday, so I signed on to his case then.
Okay, you gonna take over the?
Yeah.
Okay, perfect. There you go.
Court today, he was not able to be
Yes,
transported.
Your Honor, I do have some information for the court after, our arraignment date on Tuesday. I did call over to, the EMD office. I wasn't able to speak with anyone, but got a voicemail yesterday from the supervisor in that office. Indicated to me that, first, the prosecuting witnesses on this case did decline juris. And then second, in order to release Mr. Steinkamp to PBS with EMD, we would need to verify an address for him to go afterwards. Understanding that the court's likely to impose a stay away order, he cannot verify his normal address. I had thought about potentially 411 Guest Street, Your Honor, but he has not previously been a resident there, and so we cannot verify an address there. At this point in time, most just standard walk-in shelters are, first come, first served, and they fill up pretty quickly these days. So, Judge, I think that if we were to convert this, remove the EMD component, juris has been declined, a supervised OR with the requirement of check-ins might suffice to address the court's concerns about Mr. Steinkamp's safety and then the safety of the prosecuting witnesses.
Is he still, did Psych see him,
Have you
the
been?
jail site? Is he going to PES and the only thing holding it up is the EMD, or?
I do know that you do still have that order, Judge, that he be evaluated by psych before any release, and if necessary, transported to PES. My understanding is that if he is not transported there by jail psych, my social worker, Madeline Thompson, who is aware of Mr. Steinkamp's case being on today, would call jail records, make sure that she's notified when he's released so she can wait with him for the mobile crisis unit. They would then do their evaluation, and we think it would be necessary for him to be transported.
From the state?
Your Honor, my understanding as of the other day is that he was only to be released to mobile crisis or jail transport to PES. It was an OR EMD. I don't think EMD is a prohibition to going to PES or really any other treatment. That is our concern, is about the safety of the PWs, but also of the well-being of Mr. Steinkamp himself. That is also a very, very serious concern, I think, by all parties, given the conversations that have been had between the court, defense, and the state. So I would ask that the bond remain and that he be transported to PES and or whatever process has to occur to get him there. So, I'm sorry. Judge, I believe Mr. Steinkamp's wife is at the window as well. I'm sorry, I didn't see you there, ma'am.
Good morning, ma'am. What would you
Morning.
like to say?
I'm willing to put him up somewhere if need be. Like, I'm willing to pay for a hotel somewhere, whatever he needs. So he doesn't have to go to some shelter.
So their concern was an address after the fact, correct?
That's my
So
understanding.
then we can keep the same bond and the prosecuting witness. Did you go over there Tuesday
We
to 800 Broadway?
We did, yes, ma'am.
Can you go over there now and give them the address
Okay,
that either an address or, set up for, I believe they
because his
need a
current
week or two.
address, we leave in a couple days, so he could go back to the hotel where he's currently at.
If you would give them that address over there, just something that they can verify,
Okay,
then I'm gonna keep the bond the same.
Okay.
All right, it'll be the same bond, and I am taking Juris off because it was declined.
Yes,
And just, ma'am, we can have her put that on the record, that she's declining jurors.
She signed the paper.
yeah, they signed the paper.
Okay. Wise, Judge, these are motions to mitigate,
Yes.
both city and county.
So these are out of my courtroom.
I just happened to be his attorney also that day when we did the last
I
week.
allowed them to be put on today.
Thank you for that.
So he didn't have to wait until I returned to the.
So it appears to be a pretrial services motion, and he did successfully complete the Talbot House as we were hoping. And he reports now he's got some of the Parkway Center sober living with aftercare, sober support, doing housing help, getting his ID, birth certificate, and peer coaching and employment assistance, all kinds of positive things. So, you know, I remember him before. He seems like he's in a much better spot now than when I met him before. So this Talbot House seems to have been successful.
Mr. Wise, did you want to say anything?
Yes, I want to, thank you for giving me another chance to address my addition. Sometimes we get put in these positions, but we don't be ready. But the day that I was on my way to the justice center, I knew I was ready. So by the time I got to the Talbot House, I knew I was ready, because I learned once I got there, because a lot of people was complaining that a lot of stuff they was teaching us wasn't working. So I learned. The only way it's gonna work for you if you want it to work for you. The only way you know you want it to work for you, you gotta participate, you gotta ask questions, you gotta open up. You know what I'm saying? In addition, you gotta listen to other people speak, because then you might be put in a position where you're able to get some feedback. And that's when you start being able to learn things more about yourself. And then the more you participate, you start being able to see your path. And then you're able to make a plan that you feel that you be successful in sticking to. So that's why.
And he outlined that plan to me, so pretty succinctly.
He participated in it. I have your discharge plan that you participated with your counselor in setting up. So I know when you got here, you weren't in a good place. You weren't happy with me putting you in treatment, but you look much better now. You have a plan for success, and to me, most important is you completed something, right?
Yes.
Like,
Guess who my peer coach is? Joe Hatfield.
okay.
Your Honor.
So you have good support.
Yes.
Have you already met with him?
Yeah.
He came over
Yeah.
there?
Yeah.
Okay. All right, you got a plan.
Judge, I was given these cases this week, and I have contacted counsel for Kroger, who has contacted the AP individual for both of those. As it relates to the motion to mitigate, they would ask that the sentence remain. It's my understanding that on 7651 and 4107, those are 180 days each to run consecutively. And that statement, they would be opposed to the modification or mitigation of any sentence. Is there a 10G? Or stay away,
I don't remember.
post-conviction stay away?
The transport order, yes, I just need to get a copy. You need the, I just need a copy of it. So clerk's gonna do it. Yeah. Mr. Wise has 4 thefts on. The court has taken in consideration what the prosecuting witness stated. This court is going to give Mr. Wise an opportunity to maintain your sobriety in the community. The motion to mitigate is granted. The probation term will be 2 years. The terms of probation are to comply with your treatment and discharge plan and any probation recommendations. And then you will be on EMD. I will make it open hours so that you can go to outside meetings. But for 60 days so that you'll be on EMD while you're in IOP. Once you step down from IOP, then the EMD will come off, right? So that should be about 60 days, so long as there are no bumps in the road. And then after that, so long as there are no violations, then it'll just, the EMD will be taken off and go down to regular probation. Now, so that we're clear, you've been to treatment here, you've completed treatment here, I've mitigated you out. You're on probation to me for 2 years. So you're not gonna see nobody else but me if you come back. If you come back, are we clear about what's gonna happen?
Yes, ma'am.
What's gonna happen?
But it could remain in my son.
You're gonna stay here. All right. So I have faith that you're not gonna come back. So don't let me or you down. All right?
Yes, ma'am.
All right. Good luck. Thank you.
Thank you, Your Honor. Judge, we would ask that you stay out of Kroger's as part of probation.
All right, Mr. Wise, you know you can't go to Kroger, I didn't even need to tell you that. Okay, stay out of Kroger, thank you.
Judge Van Britton, what's next?
Oh, these, yeah,
Your Honor, this is off the 10:30 docket.
give me 1 second, there are a few documents from Mr. Wise. I think so, yeah. Okay, Mr. Britton.
Yes, Judge. I'm moving to waive his appearance. He was indicted on 2 counts and several counts were ignored. The city, it's my understanding, the city's going to dismiss the blurred windshield case.
Yes, I'm moving the court to dismiss that.
27192 is DRPA dismissed at the request of the prosecuting attorney. Is that because there's the pending felony? All right,
That's accurate.
Note that on the judge's sheet. So then I have the drug trafficking indicted, the A, the B, trafficking ignored, the C, possession indicted, D, possession ignored, and 536 ignored. All right, so those will.
Judge Simpson is next. That looks like a return on capias from city ABI.
No, it's another one of my room cases that
Oh,
I'm here
okay.
today. Good morning, Mr. Simpson.
Morning. Morning, Your Honor. Derek Wolfen, Mr. Simpson. I think this is on for a motion to mitigate today, is that right?
Yes.
Judge, like we discussed previously, Meg Morrison filed that motion, so I am not totally familiar with all the facts. However, I am aware that Mr. Simpson has completed the Talbot House 120-day inpatient alcohol treatment program. on probation for an OVI, obviously, so he is addressing the underlying issue leading to his criminality. 3 children, co-parents, all of them on the weekends, good address on Grossbeck. Got a good phone number for me, resides with his sister. She's got a job at Crow Grounds Care, and he is a graduate of Pace High School. That's what they would grant the motion filed by Ms. Morrison.
Is there anything from the city?
Well, he successfully completed the program that the court intended him to complete as far as incarceration time. There's no objection to him being released if that's what you would want. But if there's a period of probation and suspension, of course, we want those maintained.
Mr. Simpson, did you want to say anything?
I think he does want to say something, Judge.
I was told if I was rented to ask if I can do community service to kind of knock down the,
For the-
what is it?
For the costs, fines and costs?
Yes, ma'am.
I will allow community service hours. All right, so Mr. Simpson, you know what you need to do, your continuity of care plan?
Yes, ma'am.
All right, so you will be placed on ICU probation. You are to attend a minimum of 3 sober support meetings a week. You are to enroll in Calvert House Treatment and Recovery Services for IOP. You understand all of that?
Yes, ma'am. I will be able to do the Oak Street for the AA classes.
You can choose your, I don't tell you where to go to classes. You go where you feel most comfortable, and you find a group of people that you can work on your sobriety with. So I won't tell you where to go. You just have to go.
Yes, ma'am.
All right?
Yes, ma'am.
The motion to mitigate is granted. You will be on a TAD unit to monitor any alcohol, plus EMD. I'll make the EMD open hours so that you can go to any meetings that you want until you complete IOP. Once you complete IOP and you step down, then all of those 2 things will come off. It's about 60 days, all right? Those will come off, and I have put that you will comply with the treatment plan that you came up with your counselor, and you can do community service in lieu of fines and costs, and then any other probation recommendations. The probation term is 2 years. Once you're released, you'll need to go over to probation as soon as you're released, all right?
Yes, ma'am.
Thank you, good luck.
Thank you.
Are we on city DV?
City DV,
All right, give me 1 second, I have another warrant.
Is this going to go to the clerk's office?
Oh, I'm sorry,
No,
yes.
that's
Yes.
Did you look at that case?
No.
I've got another one for you. Jennifer.
Hang on. What you guys think again? Shran.
Thank you, ma'am.
That's very right.
So he is a,
Is that you, Amanda? Do you want this protection?
okay, so here he is, 1 count of theft, felony, or excuse me, county walk-in. Target,
If Raniza or Raniza Irby is here, please come on forward.
did he post or did he?
Not the physical thing, but the one we asked for. I anticipated signing correct.
So what'll happen is we'll call it, come in.
And then when you get down, will you go see the file?
Not.
I mean.
So we, traffic stuff, yeah.
Thank you.
What we'll do is we'll call.
Yeah,
we'll see
there's
if we
definitely
can
no
call
crash
felonies.
And then even with like the bids, I know I have some time when she's on the bench, but there are some judges that are just so.
No, I just need
back
to-
that I'm
Sorry.
like, let me get it done. As soon as
Court
I
is
can,
back
so
in
they can
session.
serve the operation.
All right. Irby?
Yes, sir. There was a motion for protection order, I handed it over.
They're asking me to sign a protection order to stay away, no contact.
I'm gonna call for Reniza Irby, she isn't here,
You said she is not?
not appear here.
These are siblings.
Yes, Judge. Please not guilty.
All right, as to, and he's executing the TPO.
He is.
All right, as to bond.
Esteban, he has an extremely limited record, arrest score of 1, does not reside with her, but any bond would be no bond at this point. He has one child who is 1 year old that he helps take care of, so we are asking for an OR bond at this time.
From the state.
Well, with the TPO in place, punched about the body or the facts, that's, if you'll just consider the record, the failure to appear, of course you will.
There's 1 violent felony, 1 violent misdemeanor, 0 failures to appear in the last 5. Does the state have anything, well, the state is not making a specific ask, is that correct?
Well, I should ask for juris if it's requested, but I'm not asking for money in this situation.
OR plus juris if requested. And stay away from your sister.
That's all. They'll explain it all to you. And you have my card.
All right, McCreary.
If there's a Jessica Clark, please come on up. Great.
So no objection to signing to stay away, no contact, but are objecting if it has the address, as that is Miss McCreary's apartment, and she's the only one on there. She understands if the alleged victim is at the apartment, she can't be there, but that is her apartment that she had been letting the alleged victim stay there, so.
I'm sorry, which address are you referring to?
2562 Woodburn Avenue.
I'm handing this to you now, but that is listed as the address where the defendant can be found.
Is the defendant, yes.
Yes, so not where they have to stay away from.
Perfect, then that's fine. Then we have no problem signing a stay away, no contact from her because you live at it.
Correct. So I'm the person on the lease for that apartment.
No problem.
So just so I'm clear, I'm able to go back to
If
my
she is not
residency.
there, you have to stay away from her otherwise, but yes.
How do I figure out whether or not she's in the residence so I don't put myself in a situation where we're crossing here?
Remember I told you use your mom?
Okay.
Use her first. Judge, please not guilty.
All right,
You
Miss
just signed right here versus-
Sarah allegation.
The allegation is
Is a
shove.
push.
Yep.
Shoved to the ground, injuring the back.
No record whatsoever,
No
arrest score
failure.
of 1.
Or anything from the state. She has no record as an adult or juvenile, no failure to appear, no allegation of a weapon, a full-time job, no dismissals.
Well, I would like the juris if it's requested, OR, otherwise it's fine.
Judge, the alleged victim is an individual experiencing housing instability. And we are alleging self-defense. We understand the state's request for a jurist, but that will effectively hold Ms. McCurry until Monday. So we're asking for just an OR bond with a stay away as she executed the TPO.
Does the state have a Martha's Law or some other form where there's a request for the jurist?
Well, the prosecutor does not have anything in her possession here this morning that will answer your question. So I guess that's a no at this point.
As I stated, there's no record, no failures to appear, no allegation of a weapon. Allegation is pushed to the ground, which hurt the prosecuting witnesses back. The officer, on the domestic violence victim safety questionnaire, the officer declined to fill out anything under the law enforcement section regarding injuries.
The one thing the officer did point out under facts supporting recommended bond, that the arrested's mother is going through breast cancer treatment.
The officer actually put a bond preference on here that says low bond from the police officer. Supervised OR. That's a 527, right?
Supervisor OR, okay, with a TPO. Thank you.
All right, Rodriguez.
Sorry. And there is another here.
Mr. Rodriguez might take a second for him to come out. He is a disabled veteran.
Who's the prosecuting witness? Is she present?
You're okay, so it's up to you.
Michelle Beck.
Okay.
If he needs to sit.
I advise him to
For your honor.
I appreciate that, Judge. Please not guilty. He is executing the temporary protection order. Mr. Rodriguez, the alleged victim is his spouse, or I'm sorry, partner. The plea is not guilty. As you can see, he's a disabled veteran. He is on veteran benefits and has arranged to be at Joseph House. So we will be asking for an OR bond. We have no objection to a stay away.
From the state.
I'd ask you to consider criminal record, which I do not have, and any failures to appear as to a money bond. I definitely want a jurist monitor along with that TPO. The facts here are a little bit different than the last one because I do have a victim's rights request waiver form here with everything selected. Everything's requested by this person, and the allegations are that there were observable physical injuries on Ms. Michelle Beck's face, having been allegedly caused by the fists of Mr. Rodriguez.
Two things to note. Mr. Bell brought to my attention a strangulation and domestic violence where she was the alleged victim were recently dismissed after she failed to appear at both grand jury and court. And the alleged victim's profession is mixed martial arts. So visible injuries aren't necessarily indicative of Mr. Rodriguez's actions.
So she has put on that she's requesting jurists. Are there any other specifics on there? Well, you say everything was checked, so
Well,
jurists
on the
is one
form,
of those, but is there anything else specific that's requested outside of jurists, in addition to jurists?
Oh, by me.
I do have on the domestic violence victim safety questionnaire, the prosecuting witness marked that she did not feel safe and that she believed that she was in serious harm, in danger of serious harm, or could be killed. There is 1 prior violent felony, 2 felonies, 7 misdemeanors, 6 prior failures to appear. He's executed the TPO. The prior violence looks like it was a assault out of Michigan.
I was a military after that.
And Judge, I would just state too that Mr. Rodriguez was the individual that called 911.
$5,000 secured on each count plus jurors if requested.
Thank you. Back to the regular. Yeah.
Absolute censor.
Next is Berg, Emily Berg. She's got city and county. County and city.
So Judge, my understanding is she is upstairs and unable to come to court due to her physical nature at this point. I am signing on to both. Additionally, my understanding is because I did not meet with her, I meant to get you to sign the financials form under judge certification. But I believe this will be a drug court case. This was originally Mr. Gray's, I believe.
So on the probation violations, Ms. Berg is on probation. To me, she's in change court. So I am going to put these on my change court docket for next week. We don't necessarily have to do the probation violation next week. I'm just, since she's in change court, just gonna put it back on.
Understood.
So the PV will be continued to November 5th at 1 p.m. And my KPS bond is going to remain the same on those. As to the new case,
It's F5 possession of cocaine and then accompanying misdemeanors of theft and illegal possession of drug abuse instruments.
all right, as to bond on the new cases,
Judge, we would ask for a nominal bond given that she remains home.
anything from the state? $1,000 anyway.
Thank you, Judge.
11-7 for grand jury on those.
Biddle,
You said 11.5 for change.
Oh,
Correct.
11-7 on grand jury.
yeah, 11 at grand jury,
Okay, all right.
11.5 on change court.
Right.
Yes. Good morning, ma'am. Who is Ms. Biddle's attorney?
Wait, public cause.
Ask upon.
Your Honor, she is 30 years old. She lives in Cincinnati and went to Lakota East, so she has contacts with the community. She works full-time at Earl Nails and Spa. Looking at my paperwork, she has absolutely no adult record for misdemeanors or felonies. Although it is charged as a robbery, this is a situation where the victim came up on her, had the cell phone, was filming her. My client said, stop, hit the cell phone away, she dropped it, and so they charged a robbery for force on the cell phone. So this is not your typical robbery. I would be surprised if this gets through grand jury on a robbery, so we'd ask for an OR bond.
From the state.
Judge, it's, right now, it's an F2. We'd request some type of monetary bond and a stay away, no contact with the victim. Judge, it says on my paperwork that there was an open warrant for robbery
No, there's a Mount Healthy
out of Mount Healthy.
folder. It's for fines.
Okay,
Yeah,
that,
there's a traffic case.
Right.
okay, that, the way it was worded, it was
It's
making it
this.
sound.
It was
yeah.
this case where there was, it
Okay.
looks like a warrant out when she got stopped. Is that,
Yeah,
What happened?
it's fines in court costs. She's
All right.
gonna have her brother pay it.
I saw that. I'm missing something.
this is an F2, but based on the allegations, there's no record. There are 2 prior failures to appear. It looks like on traffic cases. On seatbelt cases. $15,000 anyway, plus jurors if requested.
Do we do a OR plus EMU alternative?
Grand jury would be 11:10. Campbell?
Thank you.
Wait, probable cause.
All right, that's fine.
Mr. Campbell's 46 years old, lives in Cincinnati, so he has contacts with the community, has his GED. I know these are high-level felonies. He was very cooperative with the police. We'd ask you for that consideration and our reasonable bond.
From the state.
Judge does have 2 prior felonies, 6 misdemeanors. The, does appear they as a, it looks like the violent, or excuse me, not the violent, the felonies involve the same case. It appears involving a weapon, CCW and improper handling. The way these are charged is that they appear to be MDO, and this starts with a traffic stop by Norwood Police. Their canine alerts on the vehicle. A smaller quantity of drugs was found in the vehicle, and then they obtain a search warrant and recover more drugs at the house.
All right. These are felonies of the first degree, MDO quantities of cocaine. There are 2 prior felonies, 6 prior misdemeanors.
Judge, we'd additionally request no firearms on this because of the level of the drugs.
On the drug trafficking, 250,000 secured plus EMD. On the possession, 150,000 secured plus EMD. And no guns. Those other conditions.
Your Honor, 11:10 will be the grand jury report date.
Right. Clavier.
Clavier?
what's connected to it. No, maybe that's kind of what I said.
Yeah, the new mystery. Or the felony.
I bet she doesn't.
Your Honor, in this case, there's one count of felony theft. Appears that that revolves around a TV taken out of Second Place Bar. And that TV was valued at $2,000. The misdemeanors ending in 224 will go with the felony to grand jury.
And she has all those, I have the drug instruments.
You waive probable cause.
Yes, Your Honor.
As to bond on these.
On these, Your Honor, we're asking for a supervised OR bond. At this point, Mr. Cloutier does not have family support and doesn't presently have the means to pay a financial bond. So any monetary bond would be tantamount to no bond at this point. I understand that the court is likely to be concerned by any history of failures to appear. Those are all from older cases. When he was in a really different place in life in 2023, Mr. Cloutier was experiencing homelessness. He no longer is. He does have a stable place to stay, an apartment with a friend. He's been there for about 6 months now, and will be returning there whenever he is released. He also now has the means and the knowledge to ride the bus, which he did not have back in 2023 when those failures to appear were occurring. So I understand the court's likely to be concerned about that, but I think that those issues have been resolved now. Additionally, a social worker with my office has already spoken with Mr. Cloutier this morning. If any issues that we don't expect to pop up did pop up regarding transportation and returning to court, we would be able to sort those out as they come. But I'm very confident that he will return to court. We're asking for a supervised OR bond.
And please not guilty as to everything.
Waive probable cause on that.
Please, yes.
From the state.
Judge, based on the failures to appear, prior contacts, if any, and the fact that we respectfully request a monetary bond and EMD, stay away from that location, Second Place Sports Bar. Drugs seem to be an issue, so we would ask for randoms.
So the defendant has 1 violent felonies, 2 felonies, 1 violent misdemeanor, 9 misdemeanors, 5 prior failures to appear. I understand what counsel discussed about stability, but he has been, it appears, stable for at least 6 months on these 2023 cases. His first capias was November 28th. He was then recited, given a new court date, 1, 2, 3, 4 different times, with 2 of those being in 2025. 1 was in February, and 1 was October 20th. And so during those points in time, at least the October 20th, for sure is within the 6 months. So he was given a court date, knew the court date, had stable housing at that point in time, and still did not show up to court. So I am not doing an OR bond. That was just 2 weeks ago. 1,000 anyway. On this is the felony. Plus EMD, criminal tools, 1,000 anyway, plus EMD. Drug abuse instruments, 1,000 anyway, plus EMD. The M4 drug paraphernalia, 500 anyway, plus EMD. The possession of a dangerous drug, what level is that?
Also instruments.
M1.
Yep.
1,000 anyway, plus EMD, plus random urines on the D and E. On the capias bonds are currently at 10,000. I will put these back to 1,000, which was the last capias bond that I set. So these will be 1,000 plus EMD instead of 10,000 each.
1110 for grand jury?
Is that on everything or just the 1922?
No.
Everything but the instruments.
Everything,
I got it.
well, no, there's, the cases ending in 223 and 224 will go to the grand jury. Everything else will go to the assignment commission.
Okay, thank you.
Miguel Dean,
What was the date again?
1110. Yeah, yeah.
For a judge,
Judge, if you give me one moment, I'm gonna parse out all the Miguel Dean stuff. Six.
Judge, we're hoping to resolve the traffic.
I've got it.
There should be 3 city, 1 county.
The 27859 appears to be related to the felony.
Yeah, these are the ones I have.
They go with the ninth, the CRB and the CRA case is perfect. You don't have on your list 278?
Correct, because that's what the felony. So can we work these?
Judge, as to the old county, that is the traffic case ending in 7563. Pleaded the A, dismissed the B.
What level is that?
I believe that's a unclassified, it's a temporary permit. And then FRA is no on that.
There's a bunch of city matters. I'm offering if he pleads guilty twice to no license. It looks like his license has been canceled, which would mean he had one in the past, or minor misdemeanors both.
Which, is that 10019?
And 10346.
The A on both.
And I'll move the court to dismiss the plates charges on those, no insurance shown in either of those cases. I'm gonna go ahead and ask you to dismiss this other suspension charge too.
So 18477 is dismissed for plea.
No, I'm sorry, 18476.
I'm sorry, yes,
That's what you meant.
18476 and then 10346B and 10019B.
Oh, exactly, that's what I think you're saying, yes.
All right, yes, thank you. All right.
And that is our understanding, we have no objection.
Mr. Dean, a guilty plea is a complete admission of guilt.
Yes, ma'am.
The 2 driving without a license charges are minor misdemeanors. Maximum possible penalty is $150 fine plus costs. The temporary instruction permit charge is an unclassified misdemeanor. Maximum possible penalty is up to $1,000 in fines and costs, up to 500 hours of community service. You do have the right to a trial. Knowing your right to trial, the maximum possible penalties, do you want to maintain a guilty plea to those 3 traffic offenses?
Yes, ma'am.
I'll accept the plea. Counselor, do you waive and stipulate?
We do, and we appreciate the state's consideration. He had gone to LIP and tried to resolve this and was told until he resolved the cases, he couldn't lift anything on his license.
Finding of guilty, he's been in one night.
Yes.
All right. Is there anything else from the state?
Not on the traffic, Your Honor.
Yeah, neither from us.
On the traffic offenses, 1 day credit, 1 day remit the fines and costs. FRA non-compliance. When you release Mr. Dean, you should go back over to LIP and see what else, if anything, outside of resolving these, you need to get done so that you can get your license fixed. All right? As to bond.
This will waive probable cause on the possession of drug charge. So we're asking the court for OR bond for F5 allegations involving marijuana. Mr. Dean is amenable to treatment, report. There's no guns, no violence regarding these allegations. It's not a threat to community at this time.
From the state,
Thank you, Your Honor. We would request a monetary bond. I would note that the officer listed on his bond preference as a low bond. We would also ask, because of the history of failure to comply, or failure to appear, that he be placed on EMD as an added mechanism to ensure his reappearance in court. The drug involved is maybe 1.5 pounds of marijuana, and then that was discovered on his person and in the vehicle. The menacing is actually a little more concerning, is that he threatened a police officer. So that he was going to go flex on him and that he was going to bring all of his people.
is this the same police officer who asked for a low bond?
It is.
I'm sorry,
How are
ma'am.
you related to the case?
This is my son. It's
Okay.
his first real time being in trouble. He go to work every day. My son, y'all know he got himself in a situation, and he probably didn't realize what he was getting himself into, having that much stuff on him. I don't know what he got going on. I know my baby go to work every day, and I'm just please asking y'all, please give him a chance to get this right, please.
Thank you, ma'am.
Thank you.
Is there anything else from the state?
Judge, that is it. It appears that the menacing, possession, and the newest series of traffic cases ending in 859 will all go to the grand jury.
All right, calm down, ma'am. I understand that you're emotional. That's your baby. All right, Mr. Dean has a bunch of traffic cases that we've resolved. Why can't you make it to court, Mr. Dean?
I had missed one court date, and my lawyer was supposed to follow up with me on the court date, and she never followed up with me. I had texted her. She told me that I had missed court and that I did have the cases, but she never followed up with me for it. So, and it was literally like a day, like I think the day that I got arrested, I had just texted her like the day before.
So you have.
So it was one court date that I
You
missed.
have Mr. Gray's information, right?
I got all in my pocket right here.
And
Yes,
if you
ma'am.
don't hear from him, you're gonna call him, right?
Yes, ma'am.
Because if you don't show up, who go to jail? You or
I
him?
go to jail and I'm cool. Mhm.
We're here.
Yes, ma'am.
Mr. Dean has no record at all as an adult or juvenile. He only had these traffic offenses. The alleged drug is F5, lowest level felony, possession quantity of marijuana. The menacing is a misdemeanor of the 4th degree, and the officer requested a low bond. Based on that and the 2 prior failures to appear, and the conversation we've had here today will be a supervised OR bond.
Thank you, miss.
Make sure that you don't keep yourself in jail for the sole reason you don't come to court.
I'm gonna be here. Yes,
All
ma'am.
right. They'll be released shortly, ma'am.
11:14.
Mr. Flagg.
Mr. Flagg. Yeah.
This is Mr. Flagg, Benjamin Flagg. We're waiting for the cause on his behalf. We're asking the court for a bond charges. 5 allegation. Mr. Flagg is gained from the court as a forklift driver. He's a high school graduate of Withrow. Judge, based on the facts that I have before me, there's no allegations of any guns involved, any violence involved. He's cooperated with the authorities. He's going to appear in court. I gave Mr. Flagg all my information. He has indicated to me he will keep in contact with me through the whole process of these events.
From the state.
Judge, I know the court is aware of Mr. Flagg's record, and this is cocaine. Looks like it's less than 5 grams, making it an F5. Nothing additional.
Mr. Flagg, do you have Mr. Gray's contact information?
Yes.
All right. There is a record, 4 felonies, 1 violent misdemeanor, 15 misdemeanors. In all of that, there are 0 failures to appear. This was a small, alleged small bag of crack cocaine, possession quantity. No bond preference, it would be a supervised OR, and I am putting Mr. Flagg in random urine screens as a condition of bond.
Understand that?
1114.
Thank you. Kingston.
Wait for all the cause.
Ask him.
Mr. Hingston's 52 years old, lives in Cincinnati, so he has contacts with the community, works full-time with topics. This is a situation where the victims stole his keys and had keys to his locker at work and his keys to his house. They were messing with them because apparently they don't like him, and they would open up his front door frequently. And eventually, they opened the front door. He confronted them and said, "What are you doing? I want my keys back." That's when they came at him. The altercation ensued. So it's a self-defense claim. He denies ever having a knife, but that's the basis for the altercation. So we are asking for a move on.
Your Honor, looking at his history, it does appear, albeit it's pretty old, a felonious assault for which he did 2 years in the institution. And it looks as if he also maybe did some federal time for a cocaine charge. This case, there was a weapon used, that being the knife, at least that's the allegation. It looks also as if he tried, according to the information that we have today, that tried to cut the victim's throat with that knife, and a laceration was observed on the victim's throat by officers. Requesting monetary bond. We're also requesting EMD juris if requested and stay away. We would also request no weapons.
Two prior violent felonies, including the prior felonious assault, 9 felonies, 4 violent misdemeanors, 3 misdemeanors. There are no failures to appear on the $100,000 secured plus juris if requested.
The grand jury would be 1110. Knox.
Wait, probably cause on it. As to bond, Mr. Knox is 26 years old. He has an OR score of 2. He has
no real criminal history beyond, I think, a prior traffic conviction. The improper handling charge, he's not alleged to have misused the gun in any way. He is not barred from having a gun. He just didn't disclose to the officer that he did have the gun when asked. We would ask for an OR bond. He lives with his mother. I believe that he will report to court. Beyond that, he does work, well, he's getting a job. He had an interview and got a job offer from Kroger yesterday, so he would need to get out to start on that relatively quickly.
From the state.
Thank you, Your Honor. It appears that he was asked if he had a gun. He said no. That would be the CCW, as well as the improper handling. It does turn out that that weapon was, in fact, stolen. And then it looks like it was stolen out of Springfield Township a few years ago. And because this is a firearm case, and we respectfully request a monetary bond and no firearms during the pendency of this case as a condition bond.
Mr. Knox has no record as an adult or juvenile except for 2 minor misdemeanors. Which the minor misdemeanors are traffic and failure to appear. And then 1 prior failure to appear in the past 5, which is in front of me, which is a traffic case.
Judge, is the court willing to resolve that traffic matter now?
Yes.
You would, if the county is willing to go along with it, you would plead the A in exchange for dismissal on the B.
We are. FRA is no.
What level is it?
It's an unclassified.
It's a non-compliance. It's listed 451011 on the ticket, but I believe a non-compliance is a unclassified. If not, we can certainly treat it as such.
Mr. Knox, a guilty plea is a complete admission of guilt. This is an unclassified misdemeanor. Maximum possible penalty is up to $1,000 in fines and costs, up to 500 hours of community service. You do have the right to a trial. Knowing your right to trial and maximum possible penalties, do you want to maintain a guilty plea to 1 count of driving under suspension?
Yeah.
I'll accept the plea. Counselor, do you waive and stipulate?
We do.
And that includes waiver of service of a new complaint in Raymond.
Correct.
I'm guilty. Mr. Knox has been out for 1 day.
Correct.
Was there FRA compliant?
No.
I was working on all that. It was not, Judge.
1 day credit, 1 day remit the fines and costs. Mr. Knox, when you're released, if you want to know what you need to do to get your license valid, you go to the main courthouse. In room 167 is the license intervention program. They will tell you what you need to do. And if you qualify for a payment plan to get privileges, like to go back and forth to work, they will give you that information as well. All right? All right. The bond is $1,000 anyway on each or alternative OR EMD.
Court is in recess. This is the grand jury day.
grand jury will be 11:10.
It's like two alphabetical lists next.
This is, okay, one more.
Judge, next will be McGrady.
He's got another one, he didn't know.
Huh?
He's got one also.
You
Didn't know he
Oh,
was-
Lord.
Yeah.
You come in right in through here. I'll get it in a minute. All right, we are to one count of strangulation. Good morning, Mr. McGrady. All right. Good morning, Counselor.
Good morning, Your
Waive
Honor.
probable cause.
Yes, Your Honor, waive
As
probable
defined.
cause. Esteban, Your Honor, I'd like to enter a plea of not guilty. Shamar's 26 years old, lives here in Cincinnati. Your Honor will note that he's got no record except for traffic tickets for almost a decade now. He has a 2017 drug charge. He's got a low ORAS score of 3. He's got a good job here in town. He works at Cedar Village as a dietary aide. That's a senior assisted living facility. Your Honor, I'll note that the prosecuting witness is someone that you're going to hear from probably later today. She's actually on the docket. She's charged, I think, from yesterday with improper discharge, a felony of the 2nd degree. I know that's just an allegation, but in 2020, she was also charged with threatening someone with a firearm. She was convicted in connection with that case. So we're asking for an OR bond in this matter.
Are these out of the same incident?
Your Honor, I don't think that strictly speaking, they're cross complainants.
Judge, I am showing an address of incident of 7828 Lincoln Avenue in this one. I believe that is the same address as the discharge that I've seen earlier.
Who's representing Ms. Miller?
I am. I have her, she's next, Ms. Miller's next.
Can we bring Ms. Miller out?
Sure.
Were they arrested at the same time? Do you have the time?
I'm looking, see if I have a time stamp.
She doesn't want to come out.
Okay.
Your Honor, I'll note that Shamar doesn't have any violent misdemeanors, any violent felonies, no record of violence whatsoever.
Judge, it looks like it's occurring, I have about the same time. I would note that the time of the offense on Mr. McGrady is at 11:31. And his time of arrest was at 11:37. The time of offense for Ms. Miller is 11:37, and her time of arrest was 2 minutes later at 11:39. So if we are using that as a timeline, it seems that the offense alleged to have occurred and perpetrated by Mr. McGrady occurred before Ms. Miller's.
All right. I want to, I'm sorry. I want to switch them before I set the bond because I want to hear from her.
Sure.
So she appeared to be in fear of her coming out, so let's just switch them. While you're doing that real quick, I'm gonna look at this one.
You did say that the strangulation offense preceded the
Well, and on the, I don't know if you read it. Schmark came, forced himself back inside my home. He was already having the door, smashed the camera, and proceeded to attack me, physically choking me, pulling my hair, and choking me till she lost consciousness. So,
So.
It's my understanding that she told police.
it's squeezing me. That's what she's charged. She's charged with.
She lives in schools.
Schools.
She lives there. So it's
I'm not sure if that's not too.
what is it? 3. So
I think her record and her record, what she's got a record of is with.
She's more.
But, I mean.
It's clear.
Yeah.
When you see them.
I see that. That's charged with that.
Should be that too. This should be that too. I don't know what is it? What is it?
Serious, it's serious.
What's the state statute
On the strangulation, discharging 2923-161.
How many Pettis?
I'm making notes on both of these that are related.
How many does he have? Is that what you're asking?
This one.
13. He's got a lot going on. Robbery, DV, Oh, and endangering children on there too. He's got endangering children on there too. There's a lot. He got a lot going on. And it ranges over 2 years because it starts in 23 and it comes to this year 25. I'm not sure which one it is. A lot going on.
She
Towards
lives
back
right
session.
across, this- or like right. Half a block. Unhealthy south. Okay, all right. Judge, I think we're gonna bring Ms. Miller out.
Judge, this is Ms. Miller. Her plea is not guilty, waive probable cause. Judge, just a little bit about the facts before I go into the bond. This was an attack on Ms. Miller at her home from her boyfriend. As you can see, lift your neck up. She's got scratches on her neck, a bruise on her arm. And she did tell police that she fired a weapon into the air to get this man away from her on her front porch because she was being attacked. She is currently pregnant. She has triplets at home. She's 32 years old. She has 3 young children that are triplets. She's currently pregnant. It's a high-risk pregnancy. She's a lifelong community resident. Looks like she's been at the Lincoln Avenue residence for 1 year. She takes college courses online at Grand Canyon University. She works full-time for Dell Computers. She goes to Best Buys and different electronic stores and teaches them how to sell their products. She has no failures to appear. I show her to have a very minimal court history. She has a 1 ORS score. You could tell, Judge, that she's extremely frightened by this man who was out here before, Mr. McGrady. She was trying to protect herself and her children when this happened. And I would ask the court to consider an OR bond for Ms. Miller at this time. Thank you.
From the state.
Your Honor, we just went over the timeline, if you will, of events. Looking at the record, it looks as if she does have a prior out of Claremont County and out of a misdemeanor out of Claremont County. Locally, I believe she does have that improper. Well, she has a aggravated medicine that was dismissed. So, and then she has this. The habitation, we actually looked at the statute during the break. It is an F2 by virtue of the location of her home, which is maybe a couple hundred feet away from Mount Healthy South Elementary School. We would ask that she have a monetary bond, and in this particular case, understanding that I believe that the officers may have recovered the firearm, and that we're requesting a monetary bond, PMD.
Ms. Miller has 1 felony, 2 misdemeanors, 0 failures to appear, nothing of violence as an adult or as a juvenile. Even she's far removed from juvenile, but nothing. The addresses for the parties, Ms. Miller's address is the address that the incident allegedly occurred. It's on for both parties. Ms. Miller is here with multiple bruises that are visible. The court is concerned about shots being fired on a school day while school is in session. For purposes of bond, though, the court believes that a bond could be fashioned to mitigate that, but the allegation that Ms. Miller is claiming that she fired to stop the alleged attack on her. She was charged with improper discharge, not a felonious assault or attempted murder or something else at the defendant. The charge is in line with what has been presented today by counsel. This is an attitude, it is a serious offense, but based on her record, no violence, her explanation, the court is going to, and that this occurred at her home. The court is making this bond a supervised OR plus no guns, and I am putting on 4 weapon checks. So they will come randomly to your home and check for weapons, understand? You cannot have weapons in your home. If you do, this bond will be revoked. I'll be 100% clear on that. So you'll need to surrender any weapons that you have to a family member.
Grand jury for Ms. Miller will be 11-14.
We can bring Mr. McGrady back out.
Your Honor, on the record, I think we already waived probable cause and entered a plea of not guilty, but I did want to be heard just about a few things in relation to what we heard, if that's all right. Thank you, Your Honor. So first, I think Mr. Hickenlooper alluded to an aggravated menacing that was dismissed. I'm not sure to which case he refers, but I want to let the court know that the case I referenced earlier is 20 CRB 17083. That was a case in which the prosecuting witness was charged with threatening another woman with a gun. She was convicted of a lesser charge of disorderly conduct. That was in 2020. I think we also heard that this was a situation where she only fired in order to defend herself. Your Honor, that just doesn't match with the paper trail that we have of having previous offenses, previous allegations of using a weapon to scare other people. As I noted earlier, Shamar does not have any crimes of violence, no violent misdemeanors, no violent felonies. The record that he does has is for traffic tickets and a 2017 drug conviction. As I mentioned, he works at Cedar Village. He'd like to get back to that job. He's a dietary aide for elderly people there. He's also got an older brother, Antonio, at the hospital right now who's paralyzed as a result of a car crash. He'd like to be able to visit his brother. So given the prosecuting witness's bond, we're also asking for a bond that's reasonable in this case, OR or SOR. And sorry, the last thing, Your Honor. Shamar's got his own injuries. I've got them documented. He's happy to show them to you as well. But note that he's got dried blood on his face from where he was scratched. I think it's also his right elbow. He's got an abrasion there and a bruise. Like I said, I have those photos. I think Shamar's happy to show those to Your Honor as well. I think we just asked for that opportunity since the prosecuting witness did the same.
I mean, I can look at the picture. I don't need to show Mr. Hickenlooper. It's up to you how you do it.
You gotta show me the picture.
Show Mr. Hickenlooper first. I see it. From the state.
Your Honor, thank you. I've seen the pictures. It's really no way to tell when or how those marks got on this defendant. The I am reviewing the affidavit accompanying his paperwork. And one of the things that comes out is he forced himself back inside the home. He was smashing a camera and then physically attacked and choked her, pulled her hair and hit her, choked her until she lost consciousness. If that allegation is correct, then this may be undercharged, but I will let grand jury handle that. After she continually asked him to leave, and he wouldn't, and she was in fear for her life. Looking at the timeline of the offenses, it appears that this one preceded the discharge of the firearm. This is a violent case. She was out here a moment ago. The court had an opportunity to observe her. So we are going to ask for a monetary bond. And we are also going to ask for E&D and Juris and no weapons or firearms.
I understand what defense said about the, any priors. Those were not convictions, and the court can only deal with what it has in front of it today. The officers who did the investigation did not charge her with the aggravated menacing, a felonious assault. So her bond was based off of shooting the gun in the air. After this alleged incident, the bond, as has been stated, Mr. McGrady does not have a record. He has one prior misdemeanor. There are 10 prior failures to appear. The bond is $25,000 anyway, plus juris if requested, no firearms and weapons checks. So neither party can have weapons. The juris will be requested. If she does not request juris, then it'll just be the cash bond at 10% without E&D. And to stay away, no contact, since there's not a TPO.
Next is Moore.
He would come out and return.
Oh.
We got a grand jury day?
Oh, I'm sorry. Grand jury day will be 11/10. And it was we had 11/14 on Miller.
It's 11/10 or 11/14?
11/10 on Miller. On McGrady's 11/10.
Miller's 11/14.
Miller's 11/14. McGrady's 11/10. Yeah. Just double.
He got it.
So you got this. Miller is 11/14, correct? And McGrady is 11/10.
Increase more.
Judge, it looks like the F5 meth and a capious return from the city. One return.
Waive probable cause, Judge.
Waive probable cause. All right, Esteban.
As to bond, the possession charge is from April of this year. Ms. Moore was arrested on April 9th. She was then transferred to Dearborn County, Indiana on April 23rd. She's been incarcerated for 7 months. During that time, she completed the Matrix program and the RAP program, which are both substance use programs, and is working on getting her GED. She just has to retake one more section of it. She was released from Dearborn County on 10/27, so Monday of this week, and was reporting to probation in Hamilton County yesterday when she was arrested. She is 39 years old. She lives here locally. She has 8 kids, 2 of which she has custody of. She's working on getting a job right now. We would ask for an OR bond. She is a very limited means being that she was just released this week.
From the state.
Judge, we just refer to the record and nothing additional.
Judge, she's on probation. Do you want to handle that matter now?
No, I don't have the probation, actual probation violation.
You
got-
yeah,
I've
assuming
got a
that's
copy of the
the
complaint.
current one. Assuming that's the current. There's not more than one.
Judge, if I can correct, I'll show you what I've got as well. Sorry.
This is the same. I'll take care of it today. What's the?
Judge, I would reiterate everything that's already been put on the record. She's made significant progress towards addressing the underlying substance abuse issues. I would ask that the court either terminate the community control or reinstate. Judge, she was released on Monday, out of Dearborn County on Monday, contacted the probation officer, reported to probation yesterday, leaving her incarceration time.
What's the plea?
Guilty, sorry.
Guilty plea is a complete admission of guilt. There are 180 days minus any that you've served since sentencing that could be imposed. You do have the right to a hearing on the probation violation, which the allegations are a failure to report, failure to complete treatment, knowing the allegations, your right to a hearing, and the days that could be imposed. Do you want to maintain a guilty plea to the probation violation? There will be a finding of guilty. Is there anything besides what's already been presented?
Only reason why I wasn't able to complete the program because I got locked up, because I was born, I didn't miss no weeks.
Is there anything from the state?
No, you got it.
So the probation violation was issued in May. Ms. Moore had been compliant up until that point. She was in jail, been in jail for 7 months. So the failure to report was due to being incarcerated in a different state. And then treatment has been completed while in jail. And these are F5s, which if it's indicted, will likely go to drug court. Terminate probation. Remit the balance of days. There were not any, there was no restitution. Remit the costs. Defendant is discharged. So you're done with me, Ms. Moore. You just have this new case that was from April, all right? Is there anything from the state as to the F5 possession?
Judge, nothing in addition to what we've already stated.
Supervisor Roy. Natali?
That will be 11/14 for grand jury judge.
With probable cause, Your Honor, I'd like to enter a plea of not guilty for Mr. Natali for her F5.
F5 possession, is this going to drug court if indicted?
I am not certain, Your Honor. It wasn't flagged this morning as being eligible.
Oh, he doesn't.
Yeah, I think, yeah, some Claremont County contacts, yeah.
All right.
Maybe her as bond around.
You don't need to. What's anything from the state?
Nothing
He has a
additional,
limited
Judge.
record, no failures to appear, it's a F5.
Nothing.
Supervised OR, stay in contact with your attorney.
11:14. Pettis.
For the record, Your Honor, Dan Mike standing in for Marina Marinakis. Ms. Marinakis represents on a case that's before Judge Jenkins currently. We'll waive probable cause on the felonies. Has to be heard on bond. Mr. Pettis is 39 years old. He's a lifelong resident of Hamilton County. Currently he's living at 5424 Hamilton Avenue with his mother. He is not working right now. He tells me he's on medical leave from Clean Coat Construction, where he is a power washer. He's been there for more than 20 years. We'd ask the court to set reasonable bonds, Your Honor.
Judge, there is a request for an order of protection on the BV. Jalen Harris, is Jalen Harris in court?
Judge, I discussed the protection order with him, and he indicated that he would be willing to sign that. He doesn't live with the prosecuting witness.
Is there anything else that's
Judge, I've got them on the misdemeanors, everything Mr. White's already put on the record. They are traffic offenses. for what it's worth.
On the 23 cases where there are bonds set by the trial judge, Judge Berkowitz has set habeas bonds already on those cases and noted, please do not reduce or recall his habeas bond. This is the second time the defendant has habeas at the jury trial setting. So I am not going to modify Judge Berkowitz's bonds. He's the trial judge. They will go back to him. So those will be the same bond on the cases that have already gone before the judge. They're the same for all of them. Is there anything from anyone else on the new cases?
Judge, on the new cases, it looks like we have the domestic violence that was occurring on 10/5. Struck the mother of his children in the face with a fist. Handwriting, excuse me.
Very small.
And then the robbery is attached to that. It does as well as he's got a failure to comply from just prior to that, where he fled from police on the 27th of September. He ran multiple red lights, was on the wrong side of the road, under an ALS suspension when he was driving that vehicle. And then the traffic involved, or traffic accompanying that felony would be the driving under OVI suspension and reckless driving. That case number ends in 27861. Then additionally, it looks like there's another ticket of 27860 of unauthorized plates on that. Those would all go to the grand jury. Judge, the fact that we have a felony DD, we have F2 robbery out of a different jurisdiction, and the litany of cases that are CAFIA status, we are going to ask for a significant monetary bond, EMD, juris on the domestic if requested, EMD on the others to ensure his appearance in court. And because it's a violent felony, we'll ask for no firearms, no weapons on the robbery.
And if I may, Your Honor, there's a city 24 matter, a CRB case that looks like newly arranged, but that doesn't look related to any of this felony.
Judge, Your Honor, he was just kind of whispering to us that he looks like he was arrested in courtroom 540, so he essentially turned himself in. So
Yeah, I was present for that, Judge. He was there on a hearing date, as instructed, was arrested at that point in front of Judge Jenkins.
On the robbery and felony domestic violence, 50,000 anyway, plus EMD, plus juris if requested, no weapons. Although the no weapons, there is a, it looks like a disability already that would legally prevent Mr. Pettis from legally possessing a firearm. It looks like there was a federal case in 08. The reckless driving, 1,000 anyway, obstruction, 1,000 anyway, unauthorized license plates, OR, driving under OVI, suspension, 5,000 anyway. The suspension comes off of a third in time DUI. The failure to comply, 10,000 anyway.
So I just wanted to confirm that the 25 TRD series are going to grand jury. Is that
The
right?
2527861 will go to grand jury.
And the 860 as well?
And the 860, yes.
Perfect, thank you.
And everything else goes.
And the grand jury report will be 11/10. 11/10.
Purple. Thank you.
We have a second to write everything down. Mr. Pettis. Okay, Mr.
It was 11 what?
11/10.
Are you ready?
Yes.
On Tribble Way, probable cause.
Yes, Judge, we're gonna ask the court.
This is an F5 possession of marijuana. Is there anything from the state?
No. The traffic will go with the felony.
Supervised OR, stay in contact with your attorney.
11/14.
Thank you, Judge. Have a great day.
You too. Thank you.
So on the traffic also?
Yes.
No.
Williams.
Good morning, Judge. Corinne Hill on behalf of Mr. Williams will waive probable cause and ask to be heard as to bond. Thank you, Your Honor. As to bond, Mr. Williams has 3 children. 2 of them live with him. Another one doesn't live with him, but Mr. Williams sees that child regularly, provides financial support, and is very much a part of her life. The 2 children who do live with him, one of them turned 2 years old yesterday and has a birthday party planned for today that he very much wants to be a part of. He lives with, as I said, his 2 children, also one of their mothers. He works odd jobs. Specifically today, he was supposed to be working with an older cousin's moving company, and that's income that his family is going to miss out on because he's here today missing out on that job. They do rent their home, so of course keeping up on those payments is very, very important. The allegations in this case do not involve the use of a firearm in any way or even the display of one. It only involves being in possession of one and not disclosing that when the officer asked. There's no reason that he's not able to possess the firearm. He wasn't using it in any unlawful way. Even if the court, takes those allegations for purposes of bond, it is just not informing of the presence of that firearm. Your Honor, the only other thing that I'll note, the court may be concerned about the number of failures to appear here. Those are, as the court can see, really the only record that Mr. Williams has is traffic. Those are associated with those traffic cases. There's a couple reasons why this will be different. I'm certainly not saying that traffic offenses are not important. I'm not saying that Mr. Williams believes that they're not important, but certainly this charge is more serious than a traffic ticket, and I trust that he will take it as such and will appear in court on these charges.
Well, that cuts both ways. It could be you don't show up because it's serious, or you really are not going to show up because these are jailable offenses.
In theory, I understand what you're saying, Your Honor. However, there have been within the past 12 months other jailable offenses that he's been facing. None of those are convictions, so he does not have any convictions on his record for anything like that. But in December of last year and January of this year, he was facing jailable offenses, and those have been dismissed or ignored. He did everything that he needed to do in connection with that. So I think, Your Honor, he's shown that he does take charges seriously when they are jailable offenses at the very least.
These were Hamilton County?
Correct, Your Honor. I can give you the case numbers.
I see something from January. Is this?
And there was one from December of last year as well. In January of this year, there was B25336. There was 2 counts there that were ignored. And then in December of last year, 24 CRB 8448A and B were both dismissed. So no convictions on his record, but he showed up to court to get those dismissals. He did what he needed to do there. He will do the same here. And the other thing, Your Honor, affecting his ORAS score, 2 of the points on his ORAS score were those failures to appear. The other 2 are that he's marked as unemployed because he does odd jobs to make money for his family. So I don't think that ORAS score is really a representation of whether he'll return to court. I also don't think those failures to appear are a representation of whether he'll return to court on a charge of this magnitude. He's shown that he can do so. I'm asking for a supervised OR bond.
From the state?
Yes, Judge, thank you. Of concern is he did not disclose when asked to the officer that he had a firearm in the vehicle. And then it appears that the misdemeanor, which is an open container, was also a little concerning that alcohol was or may have been being consumed while he had a firearm. We would request a monetary bond, and the prior failures to appear are also concerning, so we would ask for EMD.
Your Honor, the only thing that I would like to add is there was another passenger in the car. I'm not sure at this moment we have enough information to fully attribute that open container to Mr. Williams. And the only other thing I'll note, he does have a stable address where he could do ENU. I just would hate for that to interfere with his ability to make it to his 2-year-old daughter's birthday party today.
Mr. McConnell Williams has no record as an adult. There are the 12 failures to appear. I did just pull up the judge's sheets on those other cases. He had an OR bond, it showed up. And I do have that. Initially, he said he didn't have it, but then he disclosed that it was under his seat. And he is not legally prohibited from having a firearm. Its allegations are how it was carried and not disclosing immediately via supervised or
1114. There is one felony walk-in, Eubanks. Jasmine Eubanks. At 5 theft from Jimmy John's.
Quick public cause, she is diversion eligible, we'd ask for an OR bond.
I said OR bond on this last night.
1114.
For this one or the last one?
Yeah. 1114 for this one.
All right, next will be Brown, county lockup.
Was the 1114 for this one? Okay, thank you. Was it this one or the last one? Yeah, it was. Okay.
Yeah, I need it too.
It was.
Please not guilty, Your Honor.
All right. Brian Brown, 2 M4s, 0 failures to appear. Is there anything from the state?
No, Your Honor. Judge, you looking to address bond further? The only thing, Judge, it indicates that he's homeless. That's not accurate. He's staying with his aunt on Ridgepoint Drive. I have a good phone number for him, but he is working.
I am going to order a stay away on the disorderly conduct to stay away from Kroger because it appears that's
Sure.
where some of this went from. It'll be OR plus Mr. Brown during the pendency of the case. You can't go to Kroger's, understand? All right, thank you. Stay away from Kroger.
Ganashara. So physical control.
Good job with the team.
He was.
Morning, Ms. Shawkins.
Judge, appears there is an ALS in place. Insurance was no.
Concur.
Is there anything, he is not guilty, is there anything on bond? He was sleeping in the car with the ignition on with indicators of alcohol. He has 1 misdemeanor, no failures to appear, no other record.
Judge, it does look like he has a present 14. And it looks like this was a
I
refusal.
don't see that on my records.
It's on the ticket.
I mean, I don't see it on the pretrial. I don't see it on my pretrial report.
He had a 2013 that was dismissed.
Judge, I'm showing a 20, it may have been pled down to a reckless operation.
You're correct. It was an OVI reckless in 2013. There was a physical control in March of 25 that was dismissed.
Correct.
I am doing OR plus no alcohol and a TAD monitor. You understand that you can have no alcohol and you will have on a monitor that will detect any alcohol consumption, and your bond can be revoked if you consume alcohol. Do you understand, sir? Thank you.
Ribbons? So 45, 10, 16. Is there a felony holder on there?
I don't see a holder. Do you see a holder?
Common please holder.
Okay.
Where's the common police holder?
I think he has other charges that are out there.
They should be on the front of that for you.
I'm showing
They're
that
on
he
the
was
front of
picked
that.
up.
B2504.
Yeah, there's vandalism.
I just want to report today for us.
Okay.
She knows.
We're just trying to figure out why you're being held on the track.
Oh, okay, sorry.
All right, what are we doing on this?
Just ask for a normal bond. Appropriate bond, considering he's being held on felony.
I'll give you that email you want. And the video ran this morning. They told me to say that to her when I come down
Okay, well,
I'm gonna put an OR bond on this, it's a traffic
there you
case.
go.
here. Thank you.
Thank you, Judge.
How?
Jennifer Howell.
This is through the video ran.
He was getting
Said that they picked him up over in on felony.
I got
So that's why I was wondering.
Is she doing something else?
She was given an OR bond this morning. I'm not sure why she's still, not for this case apparently, maybe for something else or.
I don't see any holders.
So we'll request the OR bond on this one as well, Judge. It's a minor misdemeanor, I'm not sure why she was even arrested, but not cited.
The paperwork wasn't given to the supervisor.
Okay, all right. There's the OR bond, is there anything? Plus, I am gonna order stay away from Daisy. That's where this allegedly happened.
Why stay away from Days Inn?
Because that's the.
Why?
Because I said so, and this is where it allegedly happened. So I'm giving you an OR bond, you walk out of here without paying any bond on your own. But as a condition of bond, you are not to go back there until after this case is resolved. All right? Thank you.
Oh, wait, no, I'm not done. That's not good. That's not a good.
You are, you probably wanna go while you're gonna walk out of here yourself. Sheriff Jackson?
Would you like to keep that same bond?
Huh?
Would you like to keep that same bond?
Yeah.
Please not guilty for Mr. Jackson. Looks like 3 traffic cases, Judge,
That's not.
that he needs to resolve. He understands that. Judge, if the court's not inclined to lower his bond, his case is going to decide to also have OR usually.
I am,
It's like Judge Bender's cases.
yes. So on the 2 cases, the traffic light and the unroadworthy vehicle, they currently have $5,000 cases bonds that were set by the magistrate. His trial judge set $500 bonds at 10%. I will reinstate the trial judge's bonds because she asked that her bonds not be recalled or recited, reduced. So I will reinstate his actual judge's bond, which is the 500 instead of 5,000.
At 10 on those two.
Yes.
And can we do alternate or and we just do? So
Don't change judge's bonds unless, and it was the third habeas, so she wrote on here why she did not want her bonds changed. On the new case, it's a license plate case.
That's correct, Judge.
That only has magistrate's bond, so I'll do an OR on that one. So that he only has the other two that Judge Bender already set, that he has to pay.
Thank you, Judge.
Lipscomb?
Good morning, Your Honor. Please not guilty, Your Honor. As to bond, Your Honor, he's 41. He's a lifelong resident of the Cincinnati, Warren County, Claremont County, Hamilton County area. A little bit of history, Your Honor. He just served 90 days. And the allegations here proceed when he was actually in the Butler County Jail. So these are kind of like, well, these kind of just happened before that. So he had to serve his 90 days and they're akin to the Butler County charges. So I'm assuming that these might go away, but we're asking for an OR bond in this situation so he can properly defend himself from the outside.
From the state.
Judge, the nature of the violation is what is most concerning to the state, in addition to any kind of out-of-county contacts. It does appear that this occurred on or about the 27th of July, and it looks as if he went to the protected person's house, rang the doorbell, was observed by the daughter at that location, and driving past the house several times, slowly and waiting. It almost seems like taunting type behavior. So if appropriate, we would ask for monetary bond plus juris if requested.
In addition to that, Your Honor, he worked at the Red Dog Resort and Spa for Pets. He thinks he can go back to that job. Again, I would, you can also look at his record that he does not have a violent history. And I would just add again that the two cases probably would have been combined, but for the nature of the locations, and they could not be in the same county, so to speak. One was Hamilton, one was Butler.
Your Honor, and if I may, I apologize for being a little tardy. I walked in as you guys were in the middle of this. I do have intimate knowledge of the case with Mr. Lipscomb. Counsel is correct that these both occurred within 5 days of each other. The Fairfield case was actually at the Fairfield Mercy location of their hospital. He has accepted responsibility for that. And this instance actually had occurred prior to that allegation, or now conviction, because he did plead to that, Your Honor. So I'm not trying to misrepresent that being an allegation by any means. But again, this instance was actually prior in time. My understanding is that Mr. Lipscomb's not had any contact with the complaining witness whatsoever since that case was filed and he was taken into custody. and he has been fully compliant with the protection order. I know that he does have limited financial resources. He was employed at Red Dog. He is here wearing his uniform that he was wearing at that time. So I think as far as cash bond, I know he does not really have the financial resources at this time. He was also a stay-at-home dad during the course of the marriage that is now, in the process of potentially being dissolved, but he did not have any financial resources leading up to these either. So, and again, I apologize for being tardy, Your Honor.
Nothing additional.
OR plus jurist if requested.
Thank you, Judge. So, we'll get you this information. Okay.
Daniel Long.
I won't have to set the case.
Yep, I got it. Thank you.
And, we'll come down.
I mean, did this happen yesterday?
One of them did, at least one of them did.
Oh, he's got the other one. I gotta see if there's a crash. If he pleads to 27862, three of those,
The A, B, and the C.
A, B, and the C. Dismiss the A and the B on 26001. And then plead to the A on 26497.
What level does it say?
That's an unclassified, Judge. I think the A, B, and the C, or the B is also unclassified. It's under an FRA suspension. It's a 16.
And the child restraints, are those minors or are those priors to elevate those to enforce? What are they on the document? Are they minors on the charging document?
It doesn't list the level.
Okay.
It just child restraint, 4511-81A.
All right, so these are gonna be treated as minor misdemeanors then?
We can do that, yeah.
And the 451016s are unclassified.
That is my understanding, Judge.
Mr. Long, a guilty plea is a complete admission of guilt. The two child restraint charges are minor misdemeanors. Maximum possible penalty is $150 fine plus costs. These particular charges have a mandatory minimum by law of $25 on each count. Actually, the statute has 75 on this one, so 25 to 75 is the range in which you could be fined for the child restraint violation. The driving under FRA suspensions, those are unclassified misdemeanors. Maximum possible penalty is up to $1,000 in fines and costs, up to 500 hours of community service. You do have the right to a trial on all of the charges. Knowing your right to trial, the maximum possible penalties, do you want to maintain a guilty plea to 2 counts of driving under FRA suspension and 2 child restraint violations?
Yes.
Counselor, do you waive to stipulate?
Yes, Your Honor.
And waive service of the new complaint and arraignment or any amendments?
Yes, Your Honor.
Finding of guilty, mitigation. He's been in one night.
Yes, Your Honor. 34 years old, lifelong resident of Cincinnati.
Nothing from the state, Your Honor. It doesn't appear that on the one said pled to no insurance,
You said no insurance?
no insurance.
Has a full-time job at Ford Motor Company, Your Honor, and is looking into getting his GED.
Just want to make sure I got these.
Mr. Long, did you want to say anything? You have the right to, but you don't have to.
No,
On the driving under FRA suspensions, 1 day credit, 1 day reduce the fines and costs, FRA non-compliance. On the child restraint violations, 1 day credit, the fine is mandatory, it's $25 on each. It will be referred to collections. If not paid by June 1st. On those, the other cases are dismissed for plea. Mr. Long, show up to court if you get a ticket. You sat in jail overnight on charges that you literally cannot go to jail for. There is no reason that you sat in jail tonight, except that you didn't come to court.
Yes, ma'am.
All right? Free to go. Thank you.
McIntosh.
It's very simple traffic cases. Oh, that's very so rare.
It makes sense.
Come on, Mr. All right?
Please not guilty, Your Honor.
He has no record, no failures to appear.
And it's over approximately a $1 item, merchandise.
Stay at a Dollar General. This.
Ms. McIntosh, I understand you can't go to Dollar General?
But it does appear that the officer, while he was resisting, hit her knee, significant pain and restricted mobility.
He has no record as an adult or juvenile, no failures to appear, and from what I'm reading, no bond preference from the officer. It would be supervised OR for us to stay away from Dollar General.
Judge, we've had an attorney here all morning on a walk-in, and the case is Strand.
Why didn't we put it on the early?
Mr. McIntosh is out now.
We'll do,
I mean, Mr. Mills, sorry.
okay.
Mills? That's Mills?
Yeah.
Okay. There's a request for an order of protection.
We'll do Strand after this.
Barbara Mills in court.
Yeah. He executing the TPO.
See what they said? Is there a sign date from that?
right, he's executed the TPS
Yes, Your Honor.
as to bond.
As to bond, Your Honor, he's 21 years of age. He's a resident of Norwood. I believe that's where this incident took place. I would note that in one place, the complaint just basically says the well, in one place it just says the chair that was thrown hit my shin. The other one says hit my shin and striking me in the shin, so which has two different connotations. He, in other words, did not intentionally hit his grandmother with his fist or anything like that. This was accidental. Throwing the chair may have happened, but hitting her with the chair was an accident, is what I'm trying to say. He's agreed to stay away from her. He can go somewhere else, according to my client. And we're just asking for an OR bond in this situation. He has no record.
From the state.
Judge, it looks like he may have also taken the glasses off. The victim is his grandmother, and took the victim's glasses off her face and broke them.
What I have is he came in the living room in a very bad mood. He was calling me names. He picked up a folded cot and threw it at me, hitting my shin. Then he took my glasses off my face, then broke them. That's when I called 911.
It's the police investigation report that says throwing a chair at her, striking her in the shin. And striking her in the shin. Is what I'm saying.
Oh, on the 527?
Yes, Your
Okay.
Honor, on the 527. No.
I'm going to go off of her sworn affidavit as the allegation as opposed to the summary from the officer. 5,000 anyway, plus jurors if requested.
Would you consider alternate E and B, Your Honor?
We'll go Tran. Okay. Tran?
This was a bond out, Judge.
Judge, it sounds like Mr. Tran has posted, and we just ask you to stay away from target.
He posted $1,000 standard bond.
That's correct, Your
It'll
Honor.
be the same bond. Where does he need to stay away from?
Target?
All right, understand, can't go to Target. Stay away from Target. We are on Williams. Yes, thank you.
Damon Singleton. Singleton?
Ms. Singleton has 1 misdemeanor, 0 failures to appear. Allegation is contacting the person in violation of the order in response to the sale of the marital house. Is there anything from the state?
Stay away, no contact. In any way.
Ms. Singleton, you understand? Are you the prosecuting witness?
Yes.
All right, what would you like to say, sir?
I have a TPO restraining order with Ms. Singleton. I've done a lot of different things to protect myself from her. I just asked the court that they take into consideration. I'm just trying to protect myself and for her to, whatever they can do to protect myself.
Do you want a juris monitor, which will let you know if she was within a certain radius of your home?
Yes,
Your Honor, may I speak?
Yes.
So, according to my client, this has been going on for like at least 10 months, possibly over a year. The divorce was final in December of last year, 2024. So the marital house has to be sold by order of the domestic court. And she has orders, she has reasonable accommodations in order to get property, to get clothes, to do things necessary to sell the house. And for whatever reason, those communications have been broken down in violation of the domestic judge's order because she has to have some contact with them. In this particular situation, my understanding is it was a third-party text, which is not in violation of the order, and he still is able to have her arrested on this. Don't know exactly why.
Do you have the order?
I do not, Your Honor, I do not.
I have the orders.
You have it with you? Oh, somebody has it. Two people have it.
And they,
He said that, and he went to get it.
yeah, and there's other
Somebody give me the
friends
order.
that are with her who also witnessed some of the contention that's going on between them. So I know this is not domestic court here, but as
No, I
far as the
understand, but
bond,
as bond setting, if there is something in there that says they can discuss the house,
Yes.
then I want to see it. Because the allegation is strictly a message about the house. So. This is not the right one. I need the protection order that is from September 2025. This one is 24. The violation order specific to this, the officer put it looks like it was September 4th of 2025. Here it is. I have it. It was the cover sheet. Okay. So there does not appear to be any provision that permits individual contact from the defendant to him, to the prosecuting witness. There is a provision for mediation, but not self-mediation.
So the only thing I can bring up, Your Honor, like I said, as my client understands it, or as I understand it, the order came out in October 15th, as a result of a different hearing. So it wouldn't be in September.
I'm sorry, which order came out October 15th?
It was a contempt. I have a contempt on Timmy because we were supposed to sell the house within 30 days. It's been 10 months.
And is
They
there
gave me
an amendment?
permission to get my stuff out of the house, but I had to speak indirectly to Timmy, is what I did. I didn't contact him directly.
Is there,
I
does
have 30
anyone
days.
have that?
I believe I can get a copy of the record on my phone.
That's.
Let's recall this, because this is going to determine what the bond is.
So we're on to Singleton, Dana Singleton? Or no, that was just
That was the thing.
Williams,
Williams.
Aisha Williams.
All right.
Thank you.
Good afternoon, Your Honor. Chris Kepler here with Ms. Aisha, making her way out. Plea of the not guilty. There was already, I guess she tried to pay for a meal, didn't happen. But
She has,
there's $1,000. I have no failure to appear, no conviction history.
the $1,000 is just the standard bond.
Yes, I mean, she can make that, but she wouldn't mind if you wanted to make it a warrant also.
From the state?
Looks like it's a theft from Red Squirrel. That's it.
She has 3
Stay away from Red Squirrel.
misdemeanors, 0 failures to appear. It'll be OR plus stay away from Red Squirrel Restaurant.
Thank you.
Stephen Williams.
I included it in the, and we go back.
Okay, this is our last lockup, Judge.
Go ahead. I don't know if you have anything about older.
Williams, Stephen.
That would make somewhat of a difference. Do you have-
Montgomery
Sheriff, have
County.
a older one?
Montgomery County, yes.
Okay, so could we do, some kind of I know there's well, I don't think it's even a standard one. We do a nominal bond, if it's good health in Montgomery County. I know he has a record and all that. No failure to appear history, last one.
Good morning, Mr. Is there anything from the state on the request for a nominal bond as Montgomery County holder?
Judge,
500 anyway.
stay out of Lowe's.
Is that on both? We're done close, all right? Thank you, sir.
Is that on both, Judge?
Yeah.
All right, so are we going back on
I
that?
think he found, he had it. Can we get that one, Deputy, please? That's the proper one.
She coming back out?
Let me make sure this is the right one first. We can, while I'm looking at that, we can call the walk-ins.
Just walk-ins. If you hear your name, come to the door, deputy will let you in. Clara Frisco, Jasmine Grier,
These are all.
Tatiana Reed,
I know the first two.
Alevek Turpov,
I don't have these last two.
Rapov.
All right.
This one's a bond.
All right, Miss Frisco.
Yes.
You, Mr. Tarapov, sir?
All
Is that
right.
you?
You
Pete
paid-
Tarapov? Sir?
No. All right, you paid the $1,000 10% bond last night. She has shown up here today. It'll be the same bond, and you'll go get a new court date. She has no record, no failures to appear.
She's diversion
eligible. You'll get the information for diversion as well. All right?
Thank you.
Thank you. Greer. Good morning, Ms. Greer.
Also, bond out.
All right, Ms. Greer bonded out last night at 500 at 10%. All right, this one is not conversion eligible. All right, you'll go get a new court date and then contact an attorney. All right, thank you, ma'am. You'll just go right out of this door to 117. 117. Reed, Ms. Reed. Good morning, Ms. Reed.
This may be site judge, I don't have anything to work on this one.
You're turning yourself in for your days. All right. Yes, her judge had her turn herself in today, Judge Greenberg. She has 3 days to serve on this driving OVI suspension. Commit on days. Is Turpikov.
And I don't have anything on that one either, Judge.
KPS 2500 at 12:06 p.m. Let me read this really.
All right.
All right. All right, we can bring we can bring this Singleton back out.
Are we all done?
They put her back.
Oh,
It was a little hectic. We don't have time right now.
So I have here, this is from October 22nd. There was a contempt hearing the magistrate's decisions and findings of fact. And it states that it shall not be considered a violation of the DVCPO for the parties to indirectly communicate with one another, but it has to be through the realtor. So the prosecuting witness, it looks, was in contempt for a couple of things. But they had not sold the house yet and the court was permitting contact. The court did not permit contact for any individual outside of the realtor to contact the prosecuting witness. From the allegations, there is a technical violation based on the allegations. But there is no other allegation that is listed here except contacting the prosecuting witness's spouse to get a response regarding the sale of the marital house, which was in violation of the order. So I understand the prosecuting witness is present and is saying that he is afraid, but I can only deal with what is in front of me. What is in front of me is her sending a message about the sale of the house herself, as opposed to having the realtor do it. And so for purposes of bond, the bond, and she has 0 failures to appear, there's 1 misdemeanor. The bond will be OR. Ms. Singleton, you understand that you cannot call. Only the realtor can call. If, for whatever reason, the realtor cannot communicate with both of you, then the only other person you go to is the court, and you'll have to file something else. But for the sale of the home, it has to be through the realtor. So you might want to look at the order again and get the parameters. But there is no allegation that there was any conversation or attempted conversation about anything outside of the sale of the home, from what the officers have listed. So the bond will be OR, there's a TPO in place.
And the court date that happened on the 15th, that was stamped on the 22nd right there. That is also under objection from the magistrate also, so it's on a stay right now. So there's even no contact even with the lawyer or even with the realtor because it's on a stay right now.
Well, I don't have the stay, I have that.
Okay,
So-
it just got filed, I'm sorry, I just was trying to answer that. And I just want to add that, this is, I at least want to put this on paper because, she's like a Jekyll and Hyde, so I have to do everything the legal way to protect myself. And that's what I'm doing.
I understand. Thank you.
Thank you,
That's the docket, correct?
Judge, all our 1030s. Okay. Dan did all the written pleas on those? I'll believe it. Yeah.
I have paperwork.
Okay.
They brought it to me,